over 2,000 years ago, the Roman orator, senator, and philosopher Cicero defined a commonwealth as the concern of a people, but a people is not any group of men assembled in any way, but rather an assemblage of some size associated with one another through agreement on law and community of interest. Now, again, I'll do what lawyers do well. I'll now break down that definition into three distinct elements. So I think he identifies three qualities that make a commonwealth. One, a collection of people of at least some minimal size. Two, an agreement on law, what he calls a consensus juris, the key phrase we'll come back to in a moment, and having some sort of common interest. For purposes of our talk, we will just posit that the first and third of these are met by our country. The United States is certainly, I think, of minimal size. I don't think that's a problem in terms of numbers of people or territory. And finally, there's at least, I think we could agree, some basic of common interest in terms of defense against external enemies or some form of economic prosperity. So we'll just sort of, without examining those, just assume they're true. What I want to focus on is the middle point. Is there a sufficient consensus juris? Now, this phrase is actually a bit misleading when translated in English in terms of a consensus on law. So we need to pause and think about those terms a little more. The term in Latin that he uses, jus juris, comes is a very polyvalent term, which possesses meanings beyond the simple English word law. The penumbra of meanings surrounding this word jus include law, justice, rights, procedures of justice, just behavior, court processes, power, authority. Jus also has the connotation of justice itself. And Aquinas will say jus is the object of justice, is what directed towards. This is the broader principles, I would say, of equity and even morality with which a legal system is supposed to embody. It's distinguished in Latin from the other word that we also translate as law. We have kind of an impoverished vocabulary. We have this one word for these two, which in Latin just refers to law in the sense we tend to think about it, a statute, a particular rule. So jus is a much, much broader, deeper concept. Likewise, consensus. It has different connotations, I think, than we might take it to mean. For Cicero, it embodies an agreement on the very nature and purpose of law and its relation to right, equity, and justice. This fundamental consensus on jus is established, not in the words of Cicero, by the mere opinion of men coinciding. He says, quote, "We are born for justice, and justice is established not by opinions, but by nature." This consensus is not something that shifts with the opinions of men, but is constituted by nature itself. The consensus, he means, is more of a coalescing of people around these pre-existing natural principles, but is not produced by that consensus. He is not naive to think that every single person in a commonwealth will always agree about every detail of law and justice. He says, in his words, that is impossible. But what he means by this, he says, but so that first principles will have the approval of those who believe that all right and honorable things are desirable on their own account, and that either nothing at all should be considered good unless it is praiseworthy in itself, or at least that nothing should be considered a great good except what can truly be praised on its own account. Cicero admits that there will be some plurality of opinion as to particular laws, using the word lex in that sense, as to particular rules, but that the Commonwealth cannot reach reasonable debate over these particulars without this consensus juris, this deeper consensus on fundamental worldviews. And that these first principles must be seen as desirable, again, on their own account, not simply because there is an agreement of opinions. Political authority must go about on the basis of this consensus, according to Cicero, making commonwealths sound, establishing justice, and making all people healthy. Without such a sharing of core principles of justice, he says, a commonwealth of laws is not possible. So if we jump from the past a bit closer to the present, I think at least today, prevalent political culture in America stands really fundamentally opposed from this outlook of Cicero. Contemporary law and politics seems to reject this claim in favor of what Dr. Thaddeus Kaczynski has called deep pluralism, with its, quote, ever-increasing number of not only diverse, but also irreconcilable worldviews, both secular and religious. By deep pluralism, I mean to contrast this with what I would call a simple pluralism, which is a mere diversity, which could be a diversity at various levels of race, of ethnicity, of linguistic diversity. And in fact, as Cicero observed about his own Roman Republic, and we can observe about other entities such as the Austro-Hungarian Empire, many commonwealths exist with this, what I call simple pluralism, this diversity of differences in opinions. What he means by deep pluralism is the word irreconcilable, that they're not simply diverse, but fundamentally contradictory, unable to be reconciled in some way. And again, the contemporary American experience is to accept this as a positive good for the basis of a commonwealth. One explanation of what Kaczynski has called this deep pluralism comes from the philosopher John Rawls. Modern states, according to Rawls, comprise people holding irreconcilable comprehensive doctrines, complete worldviews. Politics is not capable of assessing the truth of any of these claims that the comprehensive doctrines make, since politics has a more limited, in his view, practical application. The maintenance of an overlapping consensus of reasonable political commitments. Dr. Kaczynski summarizes Rawls's theory thus: with citizens fundamentally opposed in their understanding of religious, philosophical, and moral matters, the basis for political unity, stability, and justification in such a society could not be a shared understanding in these matters. However, because the pluralism is, quote, reasonable, in Rawls' terms, there can be fundamental consensus among these differing comprehensive doctrines, upon which a political order can be unified, stabilized, and justified. A consensus on shared political as opposed to comprehensive values. Now, fundamentally, the work of Dr. Kaczynski that I rely on here points out two problems. One, he says it's just not possible to survive with such deep divisions. But secondly, he says it's actually self-contradictory and hypocritical, that there's this facade of toleration, but it really works to simply impose a fundamental agreement on first principles as opposed to in its appearance of toleration. Rawls' overlapping consensus that underlies the political order is thus open only either to those with, quote, reasonable comprehensive doctrines, or to those with unreasonable comprehensive doctrines who agree to limit their public participation in politics to, quote, reasonable positions, thus privatizing their deeply held fundamental beliefs. The key to this process is the word reasonable. But this is a word which excludes any positions deemed unreasonable, right? And it is defined by an ever-changing views of what is reasonable. It is a product of consensus, not in Cicero's sense, with an objective third standard, but in the more modern sense of the prevailing opinions of the time. It has no basis in natural reality other than the practical politics of the day, which is the focal point for this definition of reasonableness. Public political culture possesses, in this view, the absolute authority to determine the commonly held conception of justice that is the focus of any reasonable overlapping consensus. Public opinion defines this reasonableness. This is the first and greatest commandment of Rawlsian liberal philosophy. Its acceptance is a sine qua non for participation in politics. If one's comprehensive doctrine does not justify this meta-idea of a reasonable overlapping consensus, fine, according to Rawls. But the dissenting citizen must act as if this other worldview were true, or become unreasonable, the punishment for which is banishment from political participation. Yet, a comprehensive doctrine which for the entire history of the country used to be considered reasonable can be redefined immediately as unreasonable by a new opinion, and hence banished from political discussion. And this is the point where actually the majority and dissent agree in a very fundamental way. They only disagree on where you look for that new changing opinion. Either in one case, the 9 justices on the court, or in the other, the vague concept, the people. But whichever of these instruments are used, they agree on the fundamental principle: once opinions have changed, whatever was reasonable now can become unreasonable. The conclusion in Dr. Kaczynski's work reaches is that notwithstanding Rawls' purported liberal broad-mindedness in permitting people to retain whatever comprehensive doctrines they might choose, we must, quote, adjure any foundation for political unity other than that which can and, in fact, actually unifies us, namely public political culture of the particular liberal democracy in which we happen to live at this moment in time. Those who believe there is a reality beyond this must either change their beliefs or keep their mouths shut on threat of banishment from all, quote, reasonable political discussion. Rawls's view is actually a development and very analogous to the earlier philosopher John Locke in his, quote, essay on toleration. Locke, while arguing for toleration of, quote, all religious views, in fact excludes views from his broad toleration, specifically 2. 1, Catholics, and 2, Protestants whose comprehensive doctrine, to use Rawls, not Locke's phrase, do not include Locke's particular version of latitudinarian Anglicanism, or what Locke dismisses with the phrase papists and fanatics. But for Locke, what constitutes a fanatic changes over time. It merely serves as the word to shut someone up and remove them from toleration. So, to turn even more to the present, the Obergefell v. Hodges case is a timely example, I think, to consider this fundamental question. The decision is most striking, as I said, by what unites the majority and dissent. Both fundamentally agree that marriage is one of the most fundamental aspects of human life, fundamental not only to individuals but to society as a whole, something inherently rooted in a comprehensive worldview. Both the majority and the dissent agree that what determines this issue is what is considered, quote, reasonable. Both sides, in the majority and the dissent, agree that for all human history, nobody would have considered the view of those upholding the state's laws on the definition of marriage was unreasonable. In fact, they would consider the opposite unreasonable for thousands of years, and therefore relegated to private opinion. What was once considered reasonable for both the majority and the dissent can, with either the sweeping of a pen or the sweeping of a vote in a particular state, simply banish one side from political reasonableness and exclude their worldview. That should be, in Cicero's view, the fundamental consensus. Both sides proceed on the assumption that there is no real answer to this question, no standard by which to judge their, quote, evolving standards of justice, other than those evolving standards themselves. The only real disagreement, as I said, is which organ of the government is the one that gets to banish the, quote, unreasonable people, either the court or the vague concept, the people. Therefore, neither side point to the need for any deep consensus on law and justice rooted in any standards outside changing political opinions, whether that be justices or legislatures. Today's reasonable beliefs may become tomorrow's unreasonable and vice versa, and each side excluding the other. There is no fundamental consensus on the very nature of law, but merely an ever-new opinion poll based on the facade of broad-mindedness. Cicero points to the basis of this consensus, as we've seen, being acceptance of a source of human nature and law outside of ourselves, and hence something transcending these mere opinions. He says, law was not thought up by human minds, that it is not some piece of legislation by popular assemblies, but is something eternal, which rules the entire universe through the wisdom of its commands and prohibitions. Therefore, the first and final law is the mind of the God who forbids all things and compels all things by reason. And again, the questions I raised today are with such fundamental disagreements hidden behind the facade of broad-mindedness. Can a real foundation for a true commonwealth, not merely an assembly of people looking out to make money for themselves, but a deep, fundamental commonwealth, actually prevail? And with that question, I leave you today. Thank you for your attention.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.